Welcome back to Winning Isn't Easy. In the next segment, I'm going to talk about the relationship between celiac disease and autoimmune thyroid disorders and your long-term disability insurance claim. Now, celiac disease, CD, is a small intestinal inflammatory disease that's immune-mediated, and it's a response that you will see in genetically predisposed individuals who consume gluten. Gluten is a complex found in wheat and related grains such as barley, rye, and oats. 1% of the Western population has celiac disease, which typically presents with gastroenterological symptoms, apparent malabsorption, weight loss, even things like dermatitis. Now, many disability carriers or plans deny celiac disease claims on the basis that it can be controlled by diet and therefore it's not disabling. However, it's also associated with autoimmune thyroid disorders such as Hashimoto's thyroids, Graves' disease, and other forms of thyroid disease. It's a multifactorial disorder that's caused by immune system dysfunction. Now, there's epidemiological evidence of the interplay between genetic susceptibility and environmental triggers, such as infections, diet, iodine, smoking. And there seems to be a common genetic background between those who have these problems and immunological issues. Now, often the diagnosis of celiac disease will come before a diagnosis of autoimmune disorders. And ultimately, serological testing, small intestine biopsies, genetic testing, EMA, IgA, IgC class, antibody testing can help tease all of this out. And it can prove whether you've got celiac disease and or thyroid disorder. So how does this all play into an ERISA disability claim? Well, when you apply for disability benefits, the carrier is going to want to see an objective basis for the diagnosis of the celiac disease and an autoimmune thyroid disorder. Since celiac disease is not in and of itself considered to be disabling, it's important that we're developing other medical conditions caused or contributed to by the celiac disease, or alternatively, that the thyroid disorder has caused the celiac disease. So in addition to proving the diagnosis, we want to prove the disabling symptoms of the celiac disease and any kind of thyroid disorder individually and then in combination, because we want to prove that you can't do the material and substantial duties of your own occupation or any occupation. That means you also got to understand the definition of disability and occupation as defined by your policy or plan. Think backwards. What are the occupational duties that you have difficulty doing or can't do because of either disorder? And we want to create a diary of those symptoms so that when you're asking the doctor to complete forms, they have a description not only of your occupational duties and the problems that you would be having doing those duties, but then they can connect that with the symptoms that you're having. They can correlate that, in fact, the symptoms are caused by the celiac disease or an autoimmune disorder. They can provide an objective basis for that diagnosis. They can confirm that the symptoms you're having are causally related, and then they can, in turn, address the restrictions and limitations that you're having or require because of the combination of both disorders. Now, I think it's important that you keep a diary about your symptoms, what you're eating, the fact that you are having difficulty regulating the disease, and so that the disability carrier plan can't argue that it's controlled by diet, when in fact it can't necessarily be controlled by diet. And there are other factors that are working together with that celiac disease, as I said, the autoimmune disorders, that in combination make it difficult, if not impossible, for you to perform your occupational duties or those of any occupation. You can see that it takes a teamwork with you and your physician, and if necessary, a disability attorney to help you get the disability benefits you deserve. Now, if your claim for celiac disease or autoimmune thyroid disorders or any autoimmune disorders have been denied, remember, under the ERISA statute, you'll only have 180 days in which to file an appeal. That appeal is the trial of your case. It's important, I think, at that stage to retain the services of an experienced ERISA disability attorney. That attorney is going to get a copy of the carrier's file. And what's important in that file, of course, are the adjusting notes, statements that they've taken from you. But it's just as important are the, what I call liar for hire, peer review, medical reviewers who have reviewed your medical records and given the disability carrier plan a reason to deny your claim. No objective basis of the diagnosis. The restrictions and limitations aren't supported. this disease can be controlled by diet or modified lifestyle. You need to be able to address these objections in your appeal letter. Writing a letter that says, I appeal, doesn't cut it. You and your lawyer are going to have to be working together to document, as I said, the objective basis of the diagnosis, the objective basis of the symptoms, establish why those symptoms are disabling, rebut the opinions of the liar for hire peer review doctors, and then tie it all together with a vocational rehabilitation report that explains why it is you can't do one or more of the material and substantial duties of your occupation, or how that term might be defined, or the material and substantial duties of any occupation. You just can't throw it against the wall and say, here's my appeal. That's not going to work, because the disability carrier is going to have 2 45-day periods in which to review your claim and either approve your claim or deny your claim. Maybe you have the rights to another appeal letter. And if you do, obviously you want to exercise that. But ultimately, a federal judge only gets to review what's in that carrier's claim file. Their file materials, your file materials, including your appeal. So it all goes in. But once the record is closed, the appeal process is ended, nothing new can go in unless there's a court order by the judge, and maybe a Social Security decision. But you need to understand that it's crucial, if your claim has been denied, that you're using this time to hire an attorney, have that attorney basically create the evidence that's needed to rebut the basis of the denial and submit a winning appeal. Because after that, it's too bad, so sad. I hope that you have learned a lot in this episode and you've enjoyed it. If you have enjoyed it, please like our page, leave a review, share it with your friends and family. And of course, subscribe. We love to have our viewers make comments. So if you have any questions or issues, contact us at 727-894-3188. I look forward to talking with you in the next episode of Winning Isn't Easy. Thanks.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.